Yagala kooti egiwe order egikkiriza okusumulula amasimu ga Dr. Kiza Besigye n'ag'Obedi Lutale mbu bajjemu obujulizi bwe baagala. Application eyo teyawulirwa luli lwe bagiteekayo ne tukomawo olwaleero ewulirwe. Era twabagamba nti muleete omusajja Benedict Odiek eyasweyalinga affidavit ng'agamba y'omu ku banoonyereza abapoliisi. Tumubuuze ebibuuzo atunnyonnyole ki kyayagala mu masimu ago butya bwe bagako n'ebirala bye sijja kwogera wano. Tulina ffe ebibuuzo byaffe bye twagala omubuuza. Kiti kitwewunyisiza okutuuka wano nga state bano ba prosecutor baga nti ffe twagala ebibuuzo ebyo babimulize mu kamera eri nga bannamawulire tebaliwo nga ne public teriwo, tugende mu chambers tukwate n'enzigi tuziggalewo bateekeko ne kufulu twesibire eyo tumubuulize eyo mu nzikiza ebibeeyo public ereme bimanya. Ekyo kitwewunyisizza nnyo ne twebuuza kiki kye bakweka bw'abanga ddala ayogera mazima nga byayagala bya bujulizi ddala obugamba nti bwaleeta mu kooti lwaki ayagala tugende twekweke. Ne tuwakanya okusaba kwabwe ensonga zaffe tuziwadde nga tugamba ffe twagala ayimirire mu kaguli wano witness stand annyonnyole tumubuuza akana n'akataano. Naye ate era muwulidde state yo ng'egamba nti nedda bo baagala bagende mu kamera. So kivuddemu omulamuzi nakkiriziganya ne state n'akola ruling ye n'aga nti okusinziira investigations zikyali ku stage esooka, waliwo ndowooza ebintu bye baagala okukola nga byankiso babikolere eyo mu nkukutu mu chambers. Ffe kituwakanyizza tugamba nti bw'obanga osazeewo eno kooti waliyo ate kooti ezisingako ffe twagala kweyongerayo mu kooti. Kino tukiwakanye mu nkola gye bayita eya revision. Kooti eyawaggulu High Court erina obuyinza obwetegereza mu biragiro byonna kooti eno eya wansi byewa ne baako bwebisalawo oba ebikyusaamu oba ebimenyawo oba ebikkiriza. Ate ekyo ffe kyetusabye naye state era n'ekiwakanya lwero tuli basanyufu nti final omulamuzi akkiriziganyiza naffe n'aga nti ayimiriza ebyokugenda maaso ne cross examination oba okubuuza mukulu Benedict Odiek mu kamera oba mu chambers okutuusa nga tumaliriza okugenda okujulira kwaffe mu High Court. Era omusango ne gwongezebwayo ennaku za mwezi 3 omwezi ogwokuna okujja wano mention okulaba nga we tutuuse. So kati ffe tugenda maaso n'okukola enteekateeka yaffe okuva olwaleero okulaba nga tuteekayo okujulira kwaffe. Kankuyite kujulira ne mu mateeka tekuba appeal ne mu Luganda kwe kujulira tuteekayo kujulira kwaffe ku kusalawo okugamba nti Odiek Benedict bagenda tulina mu cross examiningira mu kamera oba
open court
mu nkukutu nti tugenda tetukikkiriza era ekyo tukiwakanya ne sekuwakanya. Twagala kiragiro kya kooti eya High Court egambe nti tumuteeke mu lujjudde wano mu kooti nga amawulire weegali nga abantu bonna we bali ebibuuzo bimubuuzibwawo kubanga state ye yatandika dde ebintu bino era n'egenda ng'egira ebintu byejyoteka ku Dr. Besigye kuba katwebuuza yo lwaki state yennyini eyatandika okufulumya ebintu ebitalina mutwe n'amagulu nefulumya bu audio negamba muwulirize simanya Besigye wuuno alamuze emmundu simanya Besigye wuuno agenzaako okunoonya esente Sweden Greece wuuno simanya luddawa ne batandika okuteekayo obuloboozi obwo bagezeeko okuprejudicinga case. Kakati babuteekayo era mwalaba n'ennaku ezo nga boogera n'ebigambo bingi abasajja nga bamwenda nga boogera ebigambo bingi. Oyo Besigye yali ayagala kutta Museveni, oyo Besigye ayina kino obujulizi buno obujulizi tubulina ne batemerako bonna bawulira obujulizi bakulayije bonna bagamba obujulizi tubulina. Kati mukweka bwaki muluteeke wano mu lujjudde bw'aba Odieka abulina jangu wano yimirire mu kaguli tugende tukubuuze kataano ku bibuuzo lwaki otayagala bagende mu nkukutu. So ekyo tugenda kulemerako era tugenda kooti eya waggulu.
With the cross examination in camera and end today, when we are seeking a review of that decision, would surely not make sense. That's what I'm saying, it's common sense. Because then there will be nothing to review because the cross-examination has happened. We don't want to take the deponent through the bother of returning if the court says that we should do it in the open. It's common sense. Your Worship, also, the spirit of our argument is founded in the well-known decision of Charles Onyango Obo and Andrew Bujuni Mwenda versus the Attorney General. I wanted to point my colleague to when he said I shouldn't. In that court, my lord, it is Constitutional Appeal number 2 of 2002, Supreme Court of Uganda. His earlier submission was that the High Court doesn't bind this court. I hope you will agree that the Supreme Court binds this court. Your Worship, in that decision, the Honorable Justice Mulenga, RIP, who delivered the lead judgment, said that when a court seized with a matter becomes aware that the proceedings are under challenge or are going to be a subject of a challenge, it must wait for the decision of the higher court. The rationale is to avoid a travesty of justice and to avoid applying the law or taking action whose validity is questioned. In other words, it should wait for the higher court to make a pronouncement as to whether it should continue or not continue. That is what we are saying. We are going to the high court, which, in as far as we know, is higher than this court, and it is only good, even for the record and the judicial officer, to wait for the higher court. Your Worship, we want to avoid a scenario, as happened in the decision of the Honorable Moses Kasivante and Parminda Singh, where the lower court went ahead to conduct a recount, despite the matters being challenged by the High Court before the Honorable Justice V.F. Musoke Chibuka, RIP, whereby the judicial officer at the lower court became a subject of disciplinary proceedings. We want to avoid that scenario and say that let the court wait and we go to the High Court. We are reminded, my Worship, and we go to section 50, subsection 2 of the Criminal Procedure Act. Your Worship, the position of that section, section 50, subsection 2, is that a review cannot take place without the DPP being heard. So those proceedings of under review, these ones which are going to be under review, are going to involve the DPP. It is in that forum that the DPP is heard, has audience. The DPP cannot object to an accused person seeking to enforce their right. It is wrong. I want to assume that if my two colleagues were in the dock, they would be ashamed and angry at someone standing in their way of enforcing their right. For Mr. Biribumboka to argue that when an accused is seeking to enforce their right, they are frustrating a process. The accused persons are not the authors of the law. They are relying on a provision of the law which they are entitled to. It doesn't matter that relying on that provision of the law causes proceedings to stay. It is their right to do so, and they are fully entitled to invoke that right. Your Worship, unlike the state and these two representatives here, it is the accused persons who have no liberty. So if the delay is going to cause them to go back to prison, I shudder to think of the concern of Mr. Bilivu. They are taking the risk of sacrificing their liberty to see that the right thing is done, and they are empowered fully and to invoke their right. Your Worship, I wish to conclude by saying sorry. But the arguments by my colleagues cannot stand in the way of the rights of the accused person. The rights are provided for by law. They don't have their liberty if they choose to invoke that right. They take the inconvenience that comes with invoking that right. And lastly, Your Worship, because our colleagues blamed us for bringing this application before we filed a formal application, we just state that this court stood over the matter. The accused persons were returned to custody, which is under very tough guard, as can be seen. We didn't ask, so we didn't speak to them. We had to obey orders and stay here and wait for court. But again, as my learned friend Mr. Jatiko said, we are not asking this court to revise this decision because it doesn't have that power. We are asking the court to do what we think is reasonable, to hold on to continuing with the decision it made until the higher court revisits that decision. It is not an appeal. It's not brought under section 17. It is brought under section 48, which, if once the application is filed, the High Court will call that file. So it is not proper, Your Worship, to take your time to sit in an application to hear cross-examination when there is a possibility that those proceedings will be recalled if the court agrees that the hearing should not proceed exactly. That's our submission, Your Worship.
Stay of its own proceedings. Our friends across the aisle argued that we did not cite any provision enjoining this court to stay its own proceedings. In other words, they are suggesting there is a vacuum strongly contained. The framers of the law did not leave any vacuum in that regard. On the contrary, Your Worship, this court has unfettered powers to manage its own proceedings and processes in situations of this nature. We refer you, Your Worship, the provisions of Section 9 of the Magistrates Courts Act. If I may, Your Worship, just for emphasis sake, to read it out verbatim, how general jurisdiction is exercised. The jurisdiction of a magistrate's court shall, subject to this act and any other written law, limiting or otherwise. Yes. Let me get this one, read it from this volume. How general jurisdiction is exercised. The jurisdiction of a magistrate's court shall, subject to this act and any other written law, limiting or otherwise relating to the jurisdiction of that court or of the presiding magistrate, be exercised in conformity with the law with which the High Court is required to conform in exercising its jurisdiction by the Judicature Act. Your Worship, my interpretation of this particular provision, this court is clothed with wide jurisdiction, just like the High Court has got or enjoys that wide discretionary power in managing its processes. And I think this answers their question as to the applicability of Section 33. Since now they are satisfied that Section 33, the former Section 33, sorry, of the Judicature Act. Therefore, yeah, we are getting acclimatized to the revised date issue. And that's not the deal. So, Your Worship, the widely discretionary powers enjoyed by the High Court under the Judicature Act are the same discretionary powers vested in this Honorable Court, including powers to stay its own proceedings. And this reinforces the issue of logic that my learned friend succinctly submitted on that particular regard. And that also resonates with the spirit of Section 43 of the Judicature Act. That is the former provision that I wish to correct that of this majesty to manage its own proceedings. Your Worship, you have powers to set timelines. To say, yes, we recognize you have a right to seek for the intervention of the Superior Court by way of revision, but it's not an open check. And of course, we can draw parallels with appeals. That's why even appeals have got timelines, that you have a right to appeal within 14 days. You have a right to appeal within 30 days. So it's very simple here for the court to invoke its powers under Section 9 and 43 of the Section 9 of the Magistrate Courts Act and 43 of the Judicature Act to say, yes, we recognize you have the right, and you have clearly indicated that you are pursuing that right. We are adjourning these proceedings for a period of 2 weeks, those are 14 days, within which that right should be exercised. And in that way, justice will be done. But now look at the absurdity. If you were to deny that right now you retreat to the chambers, you go ahead with cross-examination, but still tell the accused persons or the applicants in this matter that you have a right to seek for revision of my order, when actually you have proceeded with the cross-examination. Would that really make sense? This is what we are trying to avert, that actually if you proceeded that way, Your Worship, you would be rendering the right to seek for revision illusory. It will be nugatory. It will be useless. And that will be a travesty. And that's what we are trying to challenge. And actually it will make matters worse. And it will reinforce further our application for revision if you proceeded, Your Worship. To reinforce it.
Counsel, you said you had 2 points. That's hard. Can we go to the next?
The last one, Your Worship, the accusations made against us. Very, very unfair. I don't know the words Mr. Balivuka used. Arm twisting, blackmail, doing this. He used lots of words. They were very, very uncalled for. Very, very uncalled for. I think he owes us an apology. He should retract those statements with an apology. We are here to facilitate this court to dispense justice, not to block the way to justice. If anything, actually, it's our client who are craving justice, who are interested in having justice done to them. This is not justice to Mr. Balivuka. It's not justice to any of this, but it is justice to the applicants here. So it would be very, very unfair, grossly unfair, to tell the accused persons who are seeking to enforce their rights, to get justice, that they are twisting in court, that they are blackmailing in court. Very, very unfair. So I pray that he reflects on this, and before ruling is made, he accepts to have that expanded from the record. I am appealing to his good self and conscience, to his conscience. I do so pray, Your Worship.
That the application for revision is not yet filed and therefore anticipatory at this point in time. The normal procedure, as defense has put it, is to file at High Court, which calls for the record. They have, however, indicated that time is of the essence, and since the court made the ruling this very day to proceed with the cross-examination, should court continue with the hearing of the said application, the rights of the accused to apply for revision will be trampled upon. Yes, this court can stay its own proceedings, but only upon proof of an application at High Court for which the High Court itself will call for the file, not in cases of anticipatory matters to be filed. However, to enable the accused persons exercise the right, this court shall adjourn this matter for mention to the 30th of April 2025. All the accused persons are further remanded, same date, 30th April, for mention.
Sawa yangu liko. Sawa yangu liko.
Eyagala kooti egiwe order egikkiriza okusumulula amasimu ga Dr. Kizza Besigye n'ag'Obed Lutale mbu bajjemu obujulizi bwe baagala. Application eyo teyawulirwa luli lwe bagiteekayo ne tukomawo olwaleero ewulirwe. Era twabagamba nti muleete omusajja Benedict Odiek eyasweyalinga affidavit ng'agamba y'omu ku banoonyereza abapoliisi. Tumubuuze ebibuuzo atunnyonnyole ki kyayagala mu masimu ago butya bwe bagako n'ebirala bye sijja kwogera wano. Tulina ffe ebibuuzo byaffe bye twagala omubuuza. Kiti kitwewunyisiza okutuuka wano nga state bano ba prosecutor baga nti ffe twagala ebibuuzo ebyo babimulize mu kamera eri nga bannamawulire tebaliwo nga ne public teriwo, tugende mu chambers tukwate n'enzigi tuziggalewo bateekeko ne kufulu twesibireeyo tumubuulize eyo mu nzikiza ebibeeyo public ereme bimanya. Ekyo kitwewunyisizza nnyo ne twebuuza kiki kye bakweka bw'abanga ddala ayogera mazima nga byayagala bya bujulizi ddala obugamba nti bwaleeta mu kooti lwaki ayagala tugende twekweke. Ne tuwakanya okusaba kwabwe, ensonga zaffe tuziwadde nga tugamba ffe twagala ayimirire mu kaguli wano witness stand annyonnyole tumubuuza akana n'akataano. Naye ate era muwulidde state yo ng'egamba nti nedda bo baagala bagende mu kamera. So kivuddemu omulamuzi nakkiriziganya ne state n'akola rulingi ye n'aga nti okusinziira investigations zikyali ku stage esooka, waliwo ndowooza ebintu bye baagala okukola nga byankiso babikolere eyo mu nkukutumu mu chambers. Ffe kituwakanyizza tugamba nti bw'obanga osazeewo eno kooti waliyo ate kooti ezisingako ffe twagala kweyongerayo mu kooti. Kino tukiwakanye mu nkola gye bayita eya revision. Kooti eyawaggulu high court erina obuyinza obwetegereza mu biragiro byonna kooti eno eya wansi byewa ne baako bwebisalawo oba ebikyusaamu oba ebimenyawo oba ebikkiriza. Kati ekyo ffe kyetusabye naye state era n'ekiwakanya lwero tuli basanyufu final omulamuzi akkiriziganyiza naffe n'aga nti ayimirize ebyokugenda maaso ne cross examination oba okubuuza mukulu Benedict Odiek mu kamera oba mu chambers okutuusa nga tumaliriza okugenda okujulira kwaffe mu high court. Era omusango ne gwongezebwayo ng'ennaku za mwezi 3 omwezi ogwokuna okujja wano mention okulaba nga we tutuuse. So kati ffe tugenda maaso n'okukola enteekateeka yaffe okuva olwaleero okulaba nga tuteekayo okujulira kwaffe kankuyite kujulira ne mu mateeka tekuba appeal ne mu Luganda kwe kujulira tuteekayo kujulira kwaffe ku kusalawo okwo okugamba nti Odiek Benedict bagenda tulina mu cross examiningira mu kamera oba
open court
mu nkukutu nti tugenda tetukikkiriza era ekyo tukiwakanya ne sekuwakanya twagala kiragiro kya kooti eya kooti egambe nti tumuteeke mu lujjudde wano mu kooti ng'amawulire weegali ng'abantu bonna weebali ebibuuzo bimubuuzibwawo kubanga state ye yatandika dda ebintu bino era n'egenda ng'egira ebintu byejweteka ku Dr. Besigye kuba katwebuuza yo lwaki state yennyini eyatandika okufulumya ebintuntu ebitalina mutwe na magulu nefulumya bu audio negamba muwulirize simanya Besigye wuuna alamuze emmundu simanya Besigye wuuna agenzaako okunoonya esente Sweden Greece wuuno simanya luddawa ne batandika okuteekayo obuloboozi obwo bagezeeko okuprejudicinga case kakati babuteekayo era mwalaba n'ennaku ezo nga bagerera n'ebigambo bingi abasajja nga bamwenda nga boogera ebigambo bingi oyo Besigye yali ayagala kutta Museveni oyo Besigye ayina kino obujulizi buno obujulizi tubulina ne batemerako bonna bawulira obujulizi bakulayije bonna bagamba obujulizi tubulina kati mukweka bwaki muluteeke wano mu lujjudde bw'aba Odieka abulina jangu wano yimirire mu kaguli tugende tukubuuze katano ku bibuuzo lwaki otayagala bagende mu nkukutu so ekyo tugenda kulemerako era tugenda kooti eya waggulu Dr. Besigye n'Obedi Lutale bamaze mu kkomera babakwatanga 16 November omwaka oguwedde ne babatwala mu Joint Court Martial ne tuguba ne tulwana olutalo Sematalo ne tuluwangula ng'ennaku z'omwezi 3 mu January ate era ne bajemera ebiragiro bya gundi nga bazanya jangu nkwekule bya Supreme Court ne balwawo okuleeta Dr. Kizza Besigye wa bagambye nti investigations bakalizitandika so obanga wakwata Dr. Besigye ng'ennaku z'omwezi 16 omwezi ogwe-2024 kaka tuli wano mwezi gwa kuna totandikanga ku investigation otandika butandisa ogamba oti anti-fail to delayings ani yabalemesa okuteeka ya application eno omwaka oguwedde ani yabagaana okuleeta omusango gino mu kooti ya bulijjo ne baddeyo mu kooti Martial mu Kangaroo Court so ebyo byonna bya butaliimu bya kuteekawo bintu ebitalina mutwe na magulu kwagalako obuddiisa bannayuganda naye ffe tugenda kugenda mu maaso n'okufaafaagana nabo mu mateeka tugenda kufaafaagana okutuusa nga Dr. Besigye n'Obedi Lutale bafunye obwenkanya tubakakasa tetugenda kusamuka tetugenda kusamu oyo tugenda kufaafaagana nabo. Thank you. Oluzungu lwe tubaddemu wali